Good morning. First of all, I would like to thank the organizers of this conference for giving me the opportunity to attend this international meeting in its 7th edition. It's a pleasure for me to be here in Bucharest, first time, and to talk to this audience about the harmonization of European contract law. The title is Harmonization of European Contract Law, slowly but surely. The outline of my conference will be organized in these points. One, the first steps in the background of European contract law harmonization. Second, consumer law harmonization versus contract law harmonization, because it has been too far. 3, the green paper on contract law, the different options European Union open to the European market, the European decision. 4, the choice for an optional instrument for B2B. B2B means business to business and business to consumer, B2C contracts, and some final considerations. Going to the first point, I would like to explain very briefly the background of the European contract law harmonization, which began in the 80s with 2 important projects. First and most important were the principles of European contract law. We use the acronym PECL. These principles were prepared by the Commission on European Contract Law under the leadership of Director Professor from Denmark, Ole Lando. He's now about 90 years old and he's still working on this harmonization of private law. 3 parts, the last part were published in 2002. They have been very successful and the influence has been very important in many countries where the reform of the civil codes are still ongoing. Secondly, and with lower influence, is the contract code. It was drawn up on behalf of the English Law Commission by the professor Harry MacGregor, and this was a personal commitment and not a teamwork. It was published in 1993 and is translated also to many European languages, the same as principles. So we can take into account 2 important ideas about this background, these first steps. First, the harmonization work started in Europe as an academic work, not as official work in Brussels or Luxembourg or Strasbourg. It's an academic work, bottom-up process. And the first project address contract law harmonization in general without any reference to consumer rights or consumer contracts. Only contract in general. In 2001, a communication on European contract law by the European Commission launched a process of public consultation on the problems arising from differences between member states' contract laws and on potential action in this field. I think this is 2001 is the official starting point for harmonization of contract law. In the light of these responses, the Commission issued an action plan, proposing, on one hand, to review the acquis, we use the French word, the acquis communautaire, in the area of consumer contract law, and to remove the inconsistencies and to fill gaps. And also to improve the quality and coherence of European contract law by establishing a common frame of reference. We don't call a civil code, a European civil code, but we say a common frame of reference, containing common principles for whole Europe, terminology, a common terminology, so difficult, and model rules, articles, rules, to be used by the Union legislature when making or amending legislation. So I would say that this is the moment of the split of the harmonization work, consumer law and contract law. To start with the consumer contract law, its review and harmonization, it was very important to make a comparative analysis among the different European legislation on consumer law, in order to know how different directives on consumer law have been implemented in the different European states. This work, also an academic work, was made for the European Commission by an international research work group or team directed by Professor Schulte-Nonke in cooperation with another two professors, Tuit Klesner and Martin Evers, at the University of Bielefeld in Germany in 2008. It's a very important work in this field. The scope of this study covered the 8, I would say, the most important directives on consumer law. Apart from that, since 2004, another academic group, the so-called ACI group, was created to focus on existing European Community private law. Its work has been published, always the same editorial, most of the time, Sellier is Mulche in Germany. So this, I put a photograph, the picture of the last edition of this ACI principle of this book, published in 2013, so some months ago. And the title is a bit longer, Principles of the Existing European Contract Law. We know, or we call them the ACI principle. It's also a very important academic work to take into account when we work on harmonization of our different rules. We are 27 European states, legislations, civil codes, so we have to try to know exactly what we have in common. In October of 2008, the European Commission, after all this work, decided to submit a proposal for a directive on consumer rights. Focused only on 4 directives. Introduction, that was very new, the principle of full harmonization, maximum harmonization for every European countries. But only on these 2 directives, not all our consumer law, our consumer contracts law. But the process, the legislative process was very slow, and after 4 years, the directive on consumer rights was published at last in 2011, merging only 2 directives. So they started with 8, then to 4, and at last we are now in the process of making the translation, the implementation, into our own legislation in every European countries, also here, every European members. Only 2 directives, that was the most they could do, they could find possible. Doorstep selling directive and distance selling directive, 2 important directives. Well, another recent task. It's true that, of course, from 8 to 4 and at last 2, that was very disappointing feeling in the European Commission, because the outcome was very weak, and the satisfactory result. they decided to do something. And last December 2012, as one of the 16 initiatives of the digital agenda for Europe, the European Commission decided to publish this code of European Union online rights. What does it mean? Well, this is nothing new. What they have done is a sort of mix, sort of puzzle of the different rights which were scattered in the different directives in order to make a sort of code. So the word code is not very official. It's something familiar word to call code in this sense. But maybe useful if we are, all of us are consumers. So we go to shop online, we can check before in the website of the European Commission to try to check, to know exactly what rights we have when we buy online, or if we are sellers, if we are traders, if we are business people, companies, and we want to sell online in other European countries. We are interested in the rights of consumers in other European countries different to ours. So this can be interesting and very useful. So we go step by step, very slowly in this field. When we said consumer law on one hand, contract law harmonization on the other hand. This started in 2004 by the European Commission when they published an action plan in 2003. And they outlined a plan for the development of a common frame of reference. In the beginning, it was a sort of toolbox for the Commission, for the European Commission, when presenting proposals to improve the existing and future possible European contract law. This has been the result, the outcome of the work. Two academic groups, the study group of the European Civil Code and the Acquis group, the one who drafted the Acquis principle, they have been working together since 2003, 2004. Most of its work has been done in the Netherlands, in the Universitatea van Amsterdam, part in Osnabrück, in Germany, a part, very important part in Scotland. So this is the result. This is the most important, it's an overwhelming. I put a picture in the presentation because I think it's very important to see it. The outline edition is only one book, but there is finally a full edition published in 2011 and 9, 6 volumes, sort of encyclopedia. And it's very interesting because many legal scholars from every European countries have participated in this work. You can find here not only comments of the rules, but also you can find national notes written by the national reporters from every European countries. The European countries belonging to the European Union till 2007. And it's very useful to take this, to read it, and when we have something on our desk about contracts, but not only contracts, because the draft common reference its scope is broader, not only contract, also tort, trust. So the scope is wider, is bigger. So this is, I think, is a very good book or encyclopedia for work for reference. Not only this, the French also decided to participate in the process of the harmonization of contract law. There is a very important association, as you well know, the association Henri Capitant, des Amis de la Culture Juridique Française, and Société de Législation Comparée, the two society, they joined the academic network called the European Contract Law in 2005, and decided to work on a common terminology. That's very important because we have common law and civil law, the continental law coming from Roman law, and also the common law. So we have to bring together and to go together in the European Union, and the French under the influence of the Napoleon Code, so important in our countries with the Romanist tradition. We had something to say about it. So French scholars decided to work on this project, and this is a very interesting work. It's in French, of course. The original work is in French, 2 volumes. But this is the English translation of the common terminology, very interesting, about very important European principles and guiding principles. I think this is very interesting to compare with the previous one, with the former one. And they proposed a revision version or review of the paper. Hasn't finished yet. Because the Italian scholars, well, the Accademia dei Ius Privatisti Europei, Pavia, directed under the leadership of the Professor Giuseppe Gandolfi, started to work also on harmonization of European contract law. And they published the Code Européen de Contrat. The original text was in French, not in Italian. French and Italian were the two languages, the two working languages of this team. But it's also in English, so you can check and you can also download from internet, in this case, the Code Européen or European Code of Contracts. Well, the texts are very similar, but they are different, different influence, different background, and so on. So, well, another else. Also in Trento, but with a very international group. It's very common since 90s, after Landau Commission, legal scholars at the university, every law faculties started to think about how to deal with the harmonization. And this is another group. It's called Trento Group, and now the general meetings are in Torino, not in Trento anymore, but we keep the name Trento Group. And every year, this will be the first yest when the general meeting is not going to be held because of the crisis, because they don't have money for the first time to call for a general meeting in Italy. It's a pity because since 1995 they have been working. I belong to this group, and we have been working all these years on harmonization on 3 topics: contracts, tort, and property. People not only from Europe, we have people from Brazil, we have people from Argentina, from the United States, trying to put together our ideas, our rules, our principles, and try to work on cases. This is not a very theoretical group. We work on cases, we work on practice, always. The same cases we try to analyze from the different national point of view. Okay, this is all what we have done in all these years, and in 2010 the European Commission decided to publish a green paper giving some options for progress towards the European contract law for consumer and for businesses. These were the 7 options they gave us to all European citizens. We would go to the website and to vote and to express our opinion. What do you think? Option 1 was only to publish the results. The other extreme is option 7, to publish a European civil code. Right? The 2 extreme options were ruled out at the first moment. And in the end, the chosen option was option 4. So to publish a regulation to set up an optional instrument of European contract law. There is an expert group appointed by the European Commission who drafted a feasibility study in 2011, and in the end, in autumn 2011, there was a proposal for a regulation. And this is the current proposal. We are now debating, we are now discussing, we are now talking about this proposal. We don't have anything absolutely closed yet. So this is a work in progress, and we have many doubts, many worries. We don't have time to talk about all these problems arising from this proposal, which can affect our day-to-day life in the few months. But we don't have the time. But there are problems related to territorial scope, to personal scope, about language, about terminology, very important problem, and even related to the legal